Greetings, candidates. I'm Aisha, and I represent Tort Group 15 Law Chambers. And I've been tasked with providing you with some very important information that should guide you through to the upcoming political debate. Now, under the Constitution of Barbados, which underpins the nation of Barcent's political and legal systems, the fundamental right to freedom of expression is extended to you under Section 11. This right to freedom of expression is further protected and defined under Section 20 of the Constitution, which states that this freedom includes the freedom to hold opinions, receive and communicate ideas and information, and correspond via any other means of communication without interference. However, I hasten to warn you that this is not an absolute right, and there exist certain limitations on this right. The said Section 20 of the Constitution permits the law to make restrictions based on the need to protect the reputations, rights, and freedoms of other persons. And one of the laws that has made such restrictions is the Defamation Act of Barbados. As is par for the course in a political debate, the tendency is for public interest and public figures to be heavily scrutinized, and oftentimes they come under attack with defamatory statements. And though the right of freedom of speech embraces the right to comment on political affairs and to discuss and criticize the utterances and conduct of persons, the Defamation Act does not permit one to make false statements and unproven attacks upon the integrity and moral character of individuals, whether political personalities or not. A defamatory statement is a statement which tends to lower a person in the estimation of right-thinking members of society generally. A defamatory statement may take the form of either libel or slander. However, in Barbados, and by extension Barcent, the terms libel and slander have been replaced by the single term of defamation. Now, Section 33 of the Defamation Act states that any statement made by a candidate during an election to Parliament is not a privileged statement, and it will therefore be subject to the law and penalties of defamation. I must warn you that if at any time during the political debate you do make an untrue statement about a person, and that statement is one that will lower the person in the estimation of right-thinking members of society, you will open yourself up to the charge of defamation. And once the wrong person is able to prove that, 1. The words complained of were defamatory, 2. They referred to him or her, and 3. They were published to a third party, you can be held liable for defamation of character and a case be filed against you in the Supreme Court. Now, Sections 7 and 8 of the Defamation Act provide two possible defenses that may be employed for defamation. If you can prove that your statement is true, even if it is defamatory in nature, you can employ the defense of truth. Or if the statement that was made was defamatory, but the statement made was an opinion that was on public interest, based on true facts, or was an honest expression of your views, but not actuated by malice, then a defense of comment is available to you. Candidates, I must stress that if you make a statement that seriously damages the reputation of another, you can be sued and be required to pay financial damages in compensation. Additionally, I want to caution you that if you do make any defamatory statements, not only can you be held liable, but the media house carrying the broadcast will also be held liable as publishers of the defamatory statements. Having covered all the pertinent information that you will need to guide you through this process, on behalf of the Tort Group 15 Law Chambers, I want to wish you all the best and good luck.